Hello and welcome to our podcast on the United States Supreme Court. This begins our look at the judicial branch of the federal government. So let's go ahead and see what we're talking about. So what exactly is the Supreme Court? The Supreme Court is set up by Article 3 of the U.S. Constitution, where it says the judicial power of the United States shall be vested in one Supreme Court. So it sets up that the judicial branch will be headed by a Supreme Court at the federal level, and it implies that whatever the Supreme Court says will ultimately be the law of the land, because it is going to be the highest court in the land. We find in other places in the Constitution that Congress has the ability to set up courts that are inferior to the Supreme Court. So basically, the court system beneath the Supreme Court level. So like we said, the Supreme Court ends up being the highest court in the land. And we're going to find that very few cases actually start in the Supreme Court. Some cases that deal with ambassadors or some tax codes or some other types of things may start there. But typically, the Supreme Court serves as a last court of appeals for cases that started at lower levels of government. So for example, if there's a local issue that somebody finds fault with, they may take that issue to court. If somebody loses at that level, it may move up into the state level. If someone loses there, they may choose to appeal even higher to perhaps a federal district court. And if somebody loses there, they may still continue to choose to appeal. Ultimately, the last court of appeal is going to be the Supreme Court. That is the end of the road. That is the highest court. Whatever they say goes. That is the end of the line in terms of appeals. And so the Supreme Court is definitely the head of the judicial branch. And so we need to be cognizant of that idea of checks and balances. Where does the judicial branch fit in to that three-part system where the branches of government are checking and limiting the power of each? So specifically, we can see the Supreme Court in the upper right of that chart there. So in terms of checks and balances, the Supreme Court is going to most directly judge and evaluate the constitutionality of laws, or of public policy, or of executive orders. And so in this case, the Supreme Court is judging the validity of other pieces of law or of public policy. So if the legislative branch or Congress creates a law, then the Supreme Court gets to take a look at that and make sure it fits within the bounds of the Constitution. In a similar fashion, if the president were to create an executive order, then the Supreme Court would get to examine that order for its constitutionality as well. Additionally, there are checks and balances placed upon the Supreme Court itself. One way that happens is that when a new Supreme Court justice needs to be appointed to the Supreme Court, that nomination comes from the executive branch. But then that nomination is approved or denied by the legislative branch. So we can see that the judicial branch, while it has a lot of great power in overlooking the other branches, executive and legislative, also have powers to keep an eye on the judicial branch as well. In terms of federalism, we can see that the Supreme Court at the federal level trumps all other levels. So it ends up again being the highest court in the land. So perhaps somebody files a suit in the local level courts. Somebody wins there, somebody loses. If the loser is unhappy, they may appeal and they may move up the chain to the state level. And again, if somebody loses there, they may appeal up to the federal level. And since in the system of federalism, the federal government trumps all lower levels and the Supreme Court is at that federal level, whatever it says goes for the rest of the judicial branch and for the nation as a whole. So here's some details about the Supreme Court, like who's in it? How does it work? What do they actually do? First off, there are 9 judges on the court. We don't call them judges, we actually call them justices. And the head justice is called the Chief Justice. And so that title is honorary in that their vote on any case doesn't count more or less than any of the other justices. It's just that they are kind of in charge of moderating and moving the court through its yearly docket of cases. Additionally, the Chief Justice is the one who offers the oath of office to new presidents. Additionally, the Chief Justice would serve as the judge in any federal level impeachment trial. So in case a federal official is being impeached and there's actual trial going on to see if somebody would be convicted of that charge, the Chief Justice would serve as the judge or the one moderating that trial in the case of impeachment. And so like we said before, Supreme Court justices are nominated by the president and need to be approved by the U.S. Senate. So again, here's how we have checks and balances acting upon the judicial branch. The executive branch gets to nominate, while the legislative branch needs to approve. Supreme Court justices would serve for life, and this is actually something they want. This is not some sort of prison sentence where serving for life would be a bad thing. The Supreme Court justices actually do want to serve for as long as they possibly can. They can end their career, obviously, if someone dies. A Supreme Court justice can resign when they feel that they are either no longer capable of doing the job accurately, or perhaps for personal or familial reasons. Sometimes justices do step down. And additionally, Supreme Court justices can be impeached, which again just means to bring charges. Once somebody is impeached, meaning charged with a crime, then an actual trial would have to be held to see if that person would be convicted of that offense, and then at that point, they would be removed from office. And so in the history of the United States, only one Supreme Court justice, Samuel Chase, has been impeached. He was not convicted of that charge, and so he did stay in office. So think about this in terms of why the Founding Fathers would want the Supreme Court justices to serve for life. The goal here would be to have the judicial branch be an impartial, non-political branch of the government. These people are not elected by the people. They do not answer to special interest groups. They are being appointed by the president in the executive branch, ideally so that they would be impartial judges of law that comes before them, rather than some sort of elected official who might fall prey to people trying to influence them, trying to get them to rule a certain way. So the goal is try to keep the Supreme Court as non-political as possible. And so as we look at the qualities of a Supreme Court justice, what type of people might be nominated here? The goal is to have objective judges of the law, people who use the Constitution as their basis for decision making. Therefore, the Constitution serves as their anchor. This isn't their personal philosophy. This isn't their religious philosophy or their political philosophy. It is their reading of the U.S. Constitution. Because as we know, the Constitution is an old document. It's very difficult, though, to adjust the Constitution for the modern era. The Founding Fathers weren't thinking about things like semi-automatic weapons or the internet or the use of drones in warfare. The judges have been called upon to apply a current day reading or interpretation of a very old document. But ultimately, their basis for decision-making is the Constitution. That is the goal of the Supreme Court, a non-political, unbiased look at the law. And the law of our land comes from the Constitution. But, as I'm sure you're saying, the Supreme Court seems to be pretty political these days. And that is part of the reality, because these Supreme Court justices are nominated by partisan politicians, basically presidents. There is some inherent bias in the Supreme Court based on who nominated each justice. So, for example, Republican presidents, while in office, tend to nominate justices who are a little bit more conservative in their thinking, a little bit more traditional, a little bit more slow to change in terms of how they interpret the Constitution, whereas Democratic presidents tend to nominate more liberal jurists or justices, people who study the law. Here, they tend to have a more open to change view, a more all-encompassing view of what the Founding Fathers meant when they wrote the Constitution. So Supreme Court justices don't carry the title of Republican or Democrat with them. While they may be registered in one of those parties as private citizens, and they are allowed to vote in presidential elections, those titles don't follow them into the courtroom. They are either a little bit more conservative thinkers on the Constitution, or a little bit more liberal thinkers in terms of how they interpret the Constitution. We have to use the word interpretation because the Constitution is old. it didn't cover everything that we have to talk about in 2016. So we are constantly asking these jurists to interpret a very old document and apply it to today's society. So here we see the 2015 Supreme Court. You can see it is a full complement of justices. There are 9 of them, 3 of them women, and the gentleman seated in the middle front row is John Roberts, the current Chief Justice. At the time we're making this podcast, though, in 2016, the Supreme Court only has 8 justices on it. Antonin Scalia passed away in February of 2016, and since that time, our government has struggled to fill his spot. So think back to checks and balances. Once there is an opening, either through death, somebody has resigned, or through impeachment, the process is that the president should nominate a potential justice, and the Senate should approve or deny in order to get that Supreme Court back up to its full strength. 9 justices, an odd number in case there's a tie. 9 is a good number to avoid those ties. Unfortunately, the federal government has been at odds with each other over the last couple months, and at the time we're making this, that seat vacated by Antonin Scalia is still unfilled. So what exactly does the Supreme Court do? What cases do they hear? Like we said before, very, very few cases actually start in the Supreme Court. Some exceptionally boring and uninteresting cases to the general public start there, and the Supreme Court rules on those quite often. The cases that might be of more interest to ordinary citizens, the things that kind of impact our day-to-day, tend to be cases brought to the Supreme Court by people who are unhappy with an earlier ruling. Basically, an appeal. So like we said before, if somebody loses at the state level, they might appeal that to the federal district level. If they lose again or the other side loses, the loser can appeal up the ladder. And ultimately, a case could end up in the federal Supreme Court level. Now, thousands of cases each year want to be heard by the Supreme Court. Unfortunately, that is not possible. The Supreme Court works on a schedule very similar to the school year. Their term is from about September through about June. So they can't hear thousands of cases each year. They can only hear around 80. And what they do is they review these cases and decide which ones they should hear, which ones their input is necessary for, and ultimately, sometimes which ones their input is not necessary for. So when a case is taken on by the Supreme Court, we say that that case has been granted certiorari. This means that the Supreme Court will listen to and will evaluate that case and make a ruling on it. Now, what's interesting about the Supreme Court cases is that these cases deal with constitutional level issues. They deal with cases that have a direct impact on the document of the Constitution, therefore the very fabric of our nation. So what do we mean by constitutional issues? That sounds very important, and it is. These are cases that have something to do with the Constitution and how that document should or should not be interpreted here in 2016. So these cases might ask the question, was someone's right to an impartial jury violated? That is a Sixth Amendment issue. Was someone's right to privacy violated by a state, by the government in some way? Was someone's right to free speech violated? Or was an event an unequal application of the law, a 14th Amendment issue, perhaps where one group was treated one way and another group was treated another? And so all of these phrases come from the Constitution. And if the Constitution is the law of the land, it is the highest sense of authority in our nation, that has to apply to all citizens across all 50 states. This is not, though, a criminal court. They're not going to look at, did somebody step on your lawn? Did somebody kill somebody, and were they guilty of that murder? Did somebody rob somebody? Now, sometimes the cases that are brought to them are couched in a murder trial. But the Supreme Court isn't looking at someone's guilt or innocence regarding the murder part. They are looking at the constitutional issue surrounding the murder trial. How are cases presented to the Supreme Court? In essence, lawyers on each side present their arguments. They stand up there in front of the 9 justices, or the 8 justices right now, and they present their side of the case. And this is called the oral argument phase. Each side has about 45 minutes to present their side of the case and to explain why they think their interpretation of the Constitution is correct. Now, at the same time that they're presenting their case, the justices can interrupt these lawyers at any time with any type of question they may have. The justices are trying to ask very pointed, very detailed, very difficult legal questions in order to poke holes in each side's argument, in order to get at the root issue of this constitutional question that is going on. One thing to note, this is not a jury trial. So unlike Law and Order, where somebody is accused of a crime and there's 12 people sitting off to the side who render a verdict at the end, in the Supreme Court, the 9 justices are the ones who render a verdict. So after they have heard the oral arguments, the justices retire to a conference room. They sit and talk and debate and question and try to figure out what their interpretation of the case and the Constitution really is on that issue. At some point, the justices straight up vote about who they think had the better legal argument and therefore who should win the case. Very simply, the majority rules. So if we have a 7-2 decision, whichever side of the case got 7 wins. Whoever had 2 loses. So you can see why having an odd number would be very important in the Supreme Court. Many of the more visible things that we see in the news, the things that guide our daily lives in terms of how we interact in schools or out on the street or with the police, oftentimes those are more contentious, they're more debatable, and oftentimes those decisions come down to a 5-4 split. So after they've heard oral arguments, after they have had their conference and eventually voted on who they think is in the right here, and once they've actually voted on which interpretation seems to be the most valid, the court writes opinions. These are used to explain the court's decision, to not only say, here's which side we think has the better constitutional argument, and so therefore who wins, but also why they voted this way. But we have a couple of different opinions that get written at the end of each case. So the first is the majority opinion. And so basically this is the side that won. Whoever had more votes, they will write a majority opinion. So this becomes the law of the land. This becomes, in another word, public policy. This is now the way the government and the United States needs to behave around a certain issue. So because it is at the federal level and federalism is in play, when the Supreme Court says something in their majority opinion, it applies to all 50 states and all local level governments as well. This explains why the winning side, the majority side, ruled the way they did. It explains how they interpreted the Constitution on that issue. It talks about past cases that shaped their opinion. It talks about why they voted this way. And in essence, the majority opinion is the winning side of a Supreme Court case. We could also have what's called a concurring opinion. This is also going to be on that winning side, so the side that had more justices voting for their interpretation. And basically, a concurring opinion is an explanation by a justice who might agree with the outcome of the case, but might agree for a different legal reason. So for example, if there's a case going on, the majority opinion may say, we think the Fourth Amendment was violated in this case, and therefore we side with person A. But you could have another justice who says, you know what, I agree with side A also, but I don't agree with the Fourth Amendment interpretation. I agree with a Fifth Amendment interpretation, or something like that. Basically, it's still on the winning side. And then finally, we could have what's called a dissenting or the minority opinion. This is, in essence, the losing side of that case. They gained fewer votes with the justices than the majority side. So sometimes justices will lose that debate, that interpretation, and they will still choose to write a minority opinion so that they could say, hey, we lost 6-3 on this issue, but here's why we still think the 3 votes on this case were valid. We might not have won this battle, but we still want to get into the record the idea of our legal reasoning for our 3 votes on this side of the issue. So a couple extra things, random items about the Supreme Court. When we see court case names, such as Roe v. Wade, the first name we come across is the person or the group who is filing the lawsuit. They are called the petitioner. They are the ones saying, I have a complaint. I think my rights have been violated. I want this case heard. The second name listed is the person or group who is being sued. So they are called the respondent. So in the case of Roe versus Wade, Jane Roe, which was a fake name assigned to a woman who didn't want to reveal her real name, was suing Wade, who was the district attorney of Dallas, Texas at the time. He was the one representing the government that Roe thought was violating her rights. Note also that we use the V period to show the word versus. We don't use VS or VS period. This isn't something like Hulk Hogan versus Rowdy Roddy Piper or something like that. We use V to mean versus. Additionally, anytime we type out court case names, they are italicized. Another little extra, cases can be reversed by more recent court decisions. We had mentioned Plessy versus Ferguson in 1896. Under that Supreme Court, they thought segregation was okay. They said, hey, as long as things are separate yet equal, it's okay to keep black people away from white people. But in 1954, a different group of justices, a more modern, a more liberal perhaps group, looked at that same issue of segregation, and by 1954 they said, no, you can't do that. You need to keep people together. We never get separate but equal. We get separate and crappy, but we need to keep people together. Segregation, not okay. Therefore, Brown versus Board of Education overturns Plessy versus Ferguson. Brown becomes the law of the land. This becomes what all states and all cities have to follow from 1954 on. One last thing here. If the Supreme Court does not grant certiorari or chooses not to hear a case, or if there is a tie in the voting, like say now, when there are 8 justices and we could have a 4-4 tie, then the decision rests with the previous level of court's decision. So what we mean is, if a case has made it to the federal level of the Supreme Court and they tie 4-4, then nothing changes. Whatever had been decided at the level just before the Supreme Court, that's what stays as law. Now the challenge becomes, many times these cases are held in districts around the United States. So perhaps an issue is decided by the district court down in Texas and Oklahoma. Nobody had heard that case in the Northeast District. So if an issue is brought up and the Texas district rules a certain way, and then it gets to the Supreme Court and there's a tie, whatever is decided at the district level in Texas is what stays, but only at the District of Texas level. That law does not affect the Northeast District or the Northwest District. So there is strong merit in having the Supreme Court be the ultimate end of the road, because whatever the Supreme Court decides applies to all districts, all 50 states, all cities. And so right now in 2016, when we are short a justice and we have the potential for a tie and for court cases to be bounced back to the previous decision, we have the potential for unequal application of the law, which is in itself a 14th Amendment violation. So that's about it in terms of a basic primer about the Supreme Court. I know we talked pretty quickly about a lot of this stuff. I know we got pretty in-depth in some other things. Definitely make sure you bring in any questions you might have. We'll get those answered for you in class, and we will go from there. Otherwise, thanks so much for listening, and we'll see you soon.